Okay, welcome to Chapter 10. We're going to be going through digital laws and legislation. This is definitely not going to be an in-depth look into digital laws and legislation, but what it is going to do is going to give you a very good overview of what kind of how the legal system views computer records and how we allow evidence to come into court. So by the time we're done with this, you should be able to explain the intent and fundamental concepts of search and seizure law as it applies to digital crime. Identify some situations where search and seizure is possible with a warrant and desire or describe its limits. To describe the federal statutes that govern electronic surveillance and communication networks. Discuss the issues presented regarding the admission of digital evidence at trial. So, lastly, identify and discuss the significant U.S. Supreme Court cases focusing on digital crime and evidence. And those you're actually going to read in your book. We're not going to go through each one of the cases, as that's going to be a part of one of your exercises this week. Alrighty. So, basically, search and seizure law has failed to keep up with the changes brought by increases in digital crime. We've seen this happen across the kind of the spectrum of time as we've progressed through digital crime. I remember when computers first started coming along, we had things called fax machines, and fax machine became computer law. They took out the word fax and they put computer, and voila, we now had a computer crime law instead of a fax machine or a telephone law. And as you can probably imagine, doing that, it fails pretty miserably. So one of the problems we have is digital crime is just, one, is really fast, okay, and it's rapidly moving and changing, and things within computer crime change so quickly that it's really difficult sometimes to keep up with keep the laws up to date. It takes a long time to pass a law. It takes a long time to change a law. At times it takes a long time to revise a law. And it's not something that can be done relatively quickly. So by the time laws get changed, technology may have changed, kind of making the point mute. So laws trying to stay up with something as fluid as digital crime and digital technology is certainly a challenge. Searches with warrants. In order to obtain a search warrant, law enforcement must show probable cause by establishing a crime has been committed, evidence of the crime exists, and the evidence presently exists in the place to be searched. Okay, you kind of think about this, it only makes sense. If I just can't walk up and say, hey, I want to start searching someone's house for something because in the future they may commit a crime, or I have no idea that a crime has been committed. But if I have an idea that somebody stole something and it was seen being taken into this house, I might have a robbery or a burglary, and I know where the items are at. So I know that there is evidence of the crime that would exist there because someone saw them take this package into the house. So now I know that crime has been committed and the item might be in this house, and I can get a warrant based on the idea that there should be evidence presently in that place that would corroborate or to go with the crime that I'm stating happened. Jurisdiction is the power of the court to decide a matter in controversy. Okay, and one of the things you got to remember about jurisdiction is jurisdictions are limited. So, for example, when I was at the sheriff's department in Missouri, we would have a local judge. He would, for the county, he would sign a search warrant, but I couldn't serve that in, for example, Loudoun County when we were doing AOL investigations, or if I want to do something with Yahoo or Google, I couldn't serve that in San Jose because the judge did not have a jurisdiction in those areas. So he couldn't, his order basically was useless. So what we'd have to do is send it to the other jurisdiction, and it would become something called a foreign document, and then they would stamp it, and they would add a letter on top saying that their court agrees with our court, and then they could serve it within their own county. Federal's a little bit different. Federal entities and agencies have a power across the United States, so they aren't as kind of tied to jurisdictional processes. But once you leave the continental United States, well, then our federal rule doesn't kind of stretch. So now we have jurisdictional issues once we leave the United States. So we have to work through the State Department with other national authorities to execute, search warrants and things like that in other countries. If a criminal simply provides information from a website, the victim's local court may not have grounds to exercise personal jurisdiction. All right. This may come down to where did the crime actually happen? Did it happen in your state? Did it happen in California? Was it someplace that the person was sitting when they typed in what they were doing? Or does the court view the transaction happening in the location of where the servers are actually processing that information? And there's a lot of transactional jurisdiction is really important, especially for courts, because they like to be able to identify what it is, where it is, so that they know that they have legitimate right to issue a search warrant in this case. One of the other things you got to remember is too, the courts, and it's lightly covered in here, but it's not really covered as heavily, but it's really important when you talk about search warrants or the initial parts of the search warrants. The court has to understand what the warrant's about. Okay, so when we're talking about IP addresses, and when you're talking about things that have a significant impact, you may have to stop and say, Your Honor, do you understand what an IP address is? Do you understand what a subnet is? Do you understand what an avatar is? Do you understand what it is that I'm looking for? Because the judge may sign it based on your professional understanding, but the problem is that can then be questioned whether or not the judge knew what they were signing, and you may end up losing your all of your collections, based on the fruits of the poisonous tree or an invalid search. And the fruits of the poisonous tree or anything that's gathered from an illegal act or an illegal search. So if you want to go look up Mapp versus Ohio, basically it defines your exclusionary rule. But what the exclusionary rule is designed to do is designed to keep law enforcement from doing bad things. So we don't want to have the Machiavellian prince kind of theory happening where the end justifies the means. And if I do it wrong, they'll yell at me and tell me not to do it again, but at least I'll get the evidence into court. Well, that may not happen. You may have an exclusionary rule that says you can't bring that in, or that stuff into court that was found if it was collected during an illegal search and seizure. And something that a lot of people don't know and a lot of people don't realize is that evidence doesn't become evidence until the judge says it's evidence. Okay, so until then, it's basically an artifact of a crime. Once the judge says, now this is evidence, then it comes into the court. Now it can be looked at by the jury and everybody else. But just because you collect something doesn't mean that the court has to use it or allows it. What it means is it has to meet the rules for the collection. And if you violate the rules of the collection, you're going to lose that case. Or not lose the case. You will lose the evidence, which could certainly end up making you lose your case. And I've seen many a time where evidence has been collected and basically has been thrown out because they did not follow the right rule. A lot of people say in law enforcement you should think outside the box. Well, I have a real hard time with that, because the box is your rules and parameters, and you need to think within inside that box, because if you're thinking outside that box, then you're actually doing something illegal. Expand your box to include new rules, new procedures, new processes, so that you're not in violation of anything. Because if you do violate it, again, the exclusionary rule is definitely going to come back and give you a bad day. Fruits of the poisonous tree. This is basically what they're talking about here, and that's what we used to call it when I went through the police academy a million years ago. But other pieces of evidence gained during a flawed search may be excluded according to the fruits of the poisonous tree doctrine. The fruits of the poisonous tree doctrine basically says, if anything that you gather from an illegal that leads you to other things, all those things that were gained from that illegal search are going to be lost in court. And if you ever watch Law and Order, or if you ever watch any of these shows, they always have examples of where Jack McCoy is up there fighting to get something into the testimony, or the defense attorney is always fighting to get something thrown out. And they're basically looking at this thing. What did the cops do when they gathered evidence? And when you're talking about digital evidence is really an interesting thing, because digital evidence is ones and zeros. So it's really the interpretation of the investigator that is interpreting the computer data to tell the judge or the court or the jury what actually they're looking at. So if they went and look at the raw data, they go and look at the base data, they're going to see a 0 and a 1. They're not going to see a picture. They're not going to see a text document. That's all interpreted, and that's interpreted by the software. That's interpreted by programs, things like that. So it's going to come down to the investigator's testimony and the investigator's ability to testify in court that what they have is correct. Now, if that was all gathered illegally, you can have the best investigator in the world in there, but if their warrant did not cover that piece of evidence, you're going to lose it. And I'll give you an example from a case I had a long time ago. We were doing Microsoft Office documents, and child pornography was in the Microsoft Office documents. And we did basically our search was written very narrowly, and it stated that we were looking at all documents on the computer. Well, the defense argued successfully that we never articulated in that court or in that order that we were looking at pictures. And you may think, well, what's the difference in a document if it has a picture and it's a document? And that's not true. In the old and still in Office today, you have something called object link embedding, or OLE. So the document is separate than the picture. The picture is actually embedded into the document as it's needed for processing, printing, saving and sending somewhere, but it's not actually a part of the document. So we lost evidence going into court because the court or the defense attorney successfully argued that the pictures were never included in what we were looking for on the computer, so therefore picture evidence should not be shown to the jury. The court agreed, and all of those pictures were excluded, which really was a problem for us. More recently, a police officer pulled a cell phone from an individual, and the individual was on the known watch list for children. He was a child predator, and they took his phone, and their premise for taking the phone was that he was taking pictures. Well, when they took the phone in, they did forensics on the phone, and they looked at all the text messages, and they looked at all the other stuff. Well, the court came back and said, yeah, that's fine, but your probable cause in this case was to go after the pictures that he was taking, not the text messages, because the text messages led them to a whole nother investigation. They ended up finding he was doing some other kind of crazy stuff. So all of that other stuff was thrown out because of a badly formed probable cause or a badly formed search request, because they did not specify what it is they were looking for. And the court was very clear that if they wanted text messages and all that, they should have said that. And since they didn't, and the police went ahead and searched it anyways, the court had no choice but to exclude all of those records. It can be a little confusing at times. It's not always as clear as you would think it would be. There are numerous forms of warrantless searches, including stop and frisk, consent search, exigent circumstances search, incident to arrest, plain view, border search, and searches by private citizens. We're going to go through these just. So stop and frisk. If I stop someone on the street and I'm in fear for my safety, I can certainly pat someone down to make sure they have no weapons on them or anything that will harm me or the people around me. So stop and frisk can be easily abused, especially if you're patting someone down, feel a large baggie in their pocket, you pull it out and you find drugs. Well, how many baggies have been used in injuries to police officers. So you gotta be very careful. If the baggie falls out as I move the clothing and the baggie falls out and falls on the ground, well, then it's different. Now it's in plain view, and I've found something that came off their clothing. Because I was doing a pat down doesn't negate that the substance. So stop and frisk is one that people try. The problem is it's misapplied many times, and people try to say, "Oh, well, during the stop and frisk, I found this." Well, why were you in that pocket in the first place? You didn't feel anything. Now you're turning pockets, so there's got to be some reason. So you got to be very careful with stop and frisk. Consent search. Consent search is the most commonly used warrantless search. The consent search is interesting, and at the sheriff's department I was at, we did not do a consent search without a written, signed piece of paper. As soon as the suspect signed it, we started our search, but we had them fill out so they understood exactly what it was, because a verbal consent search is normally contested in court. If someone says, "Yeah, no, go ahead and I consent to you searching," yeah, you go in, you start looking at stuff, find something, and then all of a sudden it was, "Oh, I didn't know." The cops just started searching, and now you're in a he said, she said kind of thing. Another one where we ran into warrantless or the consent search, kind of getting pulled all the time, was when you're talking to a parent. You're like, "Hey, little Bobby may have been involved in doing some weird things on the computer," and they're like, "Oh no, little Bobby's the sweetest thing in the world. He would never do that." And as soon as you start getting on the computer, you start finding some images, things like that. All of a sudden, the parents like, "Oh, stop! We're withdrawing our consent. You can't. You weren't supposed to be on the computer in the first place." So we always have to have people sign the consent search, saying, "Yeah, we were there." They weren't forced into the consent. They weren't forced to this, forced to that. And then as soon as someone pulls consent, you're done. So if I start doing a computer and the person says, "Hey, stop! I'm no longer willing to do consent." Yeah, your consent's over. At that point, at that time, kind of timestamp, your search of consensual search is done. You don't get to keep going because they gave consent at one point. Because of my size, I'm 6'7", and a larger person. Some of the defense attorneys we ran into in my past, said that because of my size, people would give me consent, not because they wanted to, but because they were afraid of me. So they had a fear. So that would be considered an illegal search if someone signed, or if I was able to make someone do something because they thought I was going to hurt them. Well, then it's an illegal search. All right, exigent circumstances. Exigent circumstance doctrine allows officers to search and seize evidence when they think, the preservation of the evidence is going to go, something's going to happen to the evidence. I have a friend that was a police officer down in Redondo, and he had a body that was on the beach. The tide was coming in, and they ended up doing a search prior because they believed that the evidence would be gone. It was a drug case, and they thought the evidence would be washed off or compromised prior to them getting their warrant down there, because the tide was coming in. They really didn't have a choice. So there are times when you have exigent circumstances. Now, where it happens though is you have an abuse of exigent circumstances sometimes. People then start, kind of thinking, well, that's kind of a norm. So anytime that I want to search someone, I'll come up with some reason why, I can search this person. And you got to be very careful of that, because if you get known as that police officer that always has an exigent circumstance, then your reputation comes before you, and then the defense attorney gets to use that against you in court. So, your legitimacy of your actual searches then, kind of really fall under question. So you be very careful with exigent circumstances. You got to make sure that there's a real need for that exigent circumstance. Search incident to arrest. Officers are allowed to search an arrested person for any weapons or any evidence on the arrestee's person in order to prevent it, concealment or destruction. So I'm arresting you for a crime, and now I do my beyond pat down search. Now what I'm doing is I'm going through and I'm cataloging or doing what's called an inventory search of you. So if I find illegal content while I'm doing that, we find a thumb drive, we find other things. Well, those are all, it's all good. If that's part of my crime. If I'm looking at you for child pornography and I find thumb drives and hard drives and things on you, well, those things are now going to go into our evidence, and we're going to see or look for a search warrant that will allow us to now copy and search that specific item now that we know what it is. Plain view. If I walk in and the item I'm looking for is sitting on the couch or sitting on the table, or where I can see it without having to move something or open a drawer or something like that, well, then it's in plain view, and I can do that. I remember going into a domestic disturbance one time, and sitting on the coffee table was a brick of hash, and so we ended up arresting him for the possession of the hash, and the domestic disturbance and some of the violence that happened there too. So just because I don't have a warrant to look for drugs doesn't matter. With plain view is if I walk in, if I'm legally there in the first place, and I see something while I'm there, I certainly can seize that item. Border searches. This is the most unrestrictive search for law enforcement. Border searches. Basically, you can look at anything coming across the borders. I mean, there's very little that you can't go into and can't search as under the border search, and it's given that broad scope because they want to keep our country safe, and they want to prevent people from bringing stuff in. So, border agents and border folks, customs and border protection, they have great latitude to do border searches and search people that are crossing in or coming into our nation. And then private citizen searches. They call this the silver platter doctrine, and this is where you see your private investigator. He shows up and he's like, "Hey, look what I just found. I found all this really cool stuff that you couldn't get to as law enforcement, but because I'm a private citizen, I went ahead and found for you." The courts really frown on that type of use of a private citizen, and you've got to be very careful that you aren't turning people into the agent or an agent of the police. For example, I really would like to get this individual's thumb drive, so I say, "Boy, I really want this guy's thumb drive," to my buddy, and my buddy goes and gets it for him and brings it back. Well, that wasn't him acting on his own. That was him acting on my behest, and therefore he's an agent of the police, and you're going to get, collared, or you're going to get caught up. You're going to lose your evidence. But someone truly bringing in something that, is kind of, useful to you, they found it, maybe a cleaning lady was going through a house, and, she was cleaning, she found something of legal content and brought it in. Things such as that, those are all good. Again, the rules are written to protect the citizenry from the government, not from each other. So, the Constitution, there is no constitutional protection on a private, to a private citizen. It's from the private citizen to the government. That's why you have the constitutional protections. You're being protected from an intrusive government. Electronic Communications and Privacy Act, or ECPA. ECPA regulates how the government can obtain and stored account information. ECPA, if you are involved in computer crime investigations, the ECPA is going to be a part of your vocabulary. You have to abide by it. There are some traps inside of the ECPA for law enforcement. ECPA is a very important act that people should know that are going to be involved in any type of lawful computer crime investigations. ECPA creates two basic categories: electronic communication service and remote computer service, or communication service and remote computer service. These are categories that allow us to, tap phones, go after people's email. All those types of things fall within the statutes of the ECPA. And then we have our Patriot Act. The Patriot Act was passed after 9/11, and this is basically, it was a rule put in place to protect us from further terrorist acts. And there was there's a great belief that a lot of the stuff that was done during the 9/11 attacks came from the the use of computers during the run up to the 9/11 attacks. So 9/11 the Patriot Act is an enhancement of the search. It allows you for a greater and broader search. It reduces the requirements for searches, and it can be used in lots of different types of cases, but they all have to be related back to some type of national threat, terrorism, something such as that. This is not a change to the rules of search and seizure. This is certainly an enhancement to them. The Communications Assistance for Law Enforcement Act, CALEA, requires telecommunication companies to modify the design of their equipment. Basically, this allows you to go into a Verizon, AT&T, your local ISP and say, hey, we're here to put this program on, and you should be able to relatively easily put your device on, because your device should be able to be used by that ISP. And it is a law that is designed to make sure that we're able to collect, able to get in and look at those computer components or hard drives, etc. Admitting evidence at trial. Computers typically, or courts have typically admitted computer records upon assuring that records all within the business records exception to the federal rules. Computers that contain text can typically be divided into two categories: computer-generated records and computer-stored records. What this is really going to come down to is the hash values you apply to your evidence. When you collect evidence, you're going to hash everything, and hash is basically like a digital fingerprint that you put on a record. If I do an EO1 file or an encase file where I encapsulate the drive, I'm going to put a hash value on that, so I know exactly what the value of all the values inside of that digital container are. If anything has changed inside that digital container, my 26-digit hash value will change, and I'll know that there's been some tampering to my my evidence. So the hash values can be very important to us, and they are used pretty routinely to identify evidence that we capture. There's computer-generated records. These are your printouts. These are anything that is generated out. It could actually be screen metadata. There has been some work done on the memory of monitors in very recent times. And then computers or stored records, things stored on the actual computer itself. Again, creating an image file of the hard drive, and then hash valuing that. There's a lot of pictures out there that have been hashed, especially in the child pornography arena. And what happens is you run that against a known list. So you have your known list from the National Center of Missing and Exploited Children. You run that list against the list of images you found on the computer, and if you have matches, you know that you have an exact match of a picture of illegal content. So this will make your life a lot easier, because now you can go back and you can get the full bio of the child. You have pre-existing court cases that have used this, so you have a place to start, so to speak. All right, authentication. Before the government or defendant can move for the admission of computer records evidence, the authenticity of the record must be proven. Again, we're back to our hash value. You're creating that specific value for that file. If you want to, after this presentation, go out and look up the hash values and how hash values are looked by law or used by law enforcement. It'll take you through the creation of the 26-digit hash value. Most law enforcement uses something called the MD5 hash, and then we also have the SHA and SHA-1, SHA-2 hash that have different values or different algorithms for creating the signature for digital evidence. But again, the hash is extremely important. 3 forms of challenge the authenticity. Question whether the records were altered, manipulated, or damaged after they were created. So if a defense attorney comes in and says, hey, how do I know that this data was not manipulated? Where did you store it? Do you have a desktop safe? So when you left to go to the bathroom, did you leave the thumb drive sitting on the desk? And if you did, then how do I know people didn't put in your put all this illegal evidence on the thumb drive while you were in the bathroom? And this is why we image files. So we'll image the file, image the drive, image the thing. Then the original evidence goes into our evidence container, and we work from a duplicate copy of the actual evidence drive. We never work from the live evidence. That way you always have a container that you can go back to if you need to recreate the evidence. Well, I can go back to the container, I can re-image the file, and I now have my evidence back that I can work on. So duplicating the evidence or making a duplicate image of it is very easy, where I don't affect the original evidence. And that's one of the things that we have to make sure is we never change that original evidence. Challenge the reliability of the computer program that generated the records. Okay, now we're going after sometimes it's just a unicorn kind of defense where they say, well, couldn't have somebody have connected up and dumped all this, and couldn't somebody, or sort of, they're driving through the airport, couldn't somebody have wirelessly or Bluetooth stuff onto their drive? So you have all these kind of what we call unicorn defenses. And you also have to make sure that you do have there is a certain expectation that you're going to do a little due diligence on there. So if the guy nothing really makes sense, and he has child pornography on his computer, for example, you may ask him, how long have you had this computer? You may find out he just bought this computer from a yard sale a couple of months ago, and never wiped the drive or cleaned the computer, and those files may be residual. You may actually be looking at this individual incorrectly. He may actually be or in possession, but not know he was in possession of those records. That's happened before, where the wife turns the husband in, or the son reports it to a teacher, and you go out there, and the father or the mother actually has no idea that those pictures are on the computer because they've never seen them, and next thing you know, they're being arrested for child pornography. Challenge the authenticity of computer stored records by questioning the identity of their author. Where did they come from? Who made them? For example, an unopened email doesn't belong to the recipient. Only after opening it does the email belong to the recipient. So if I have an open email and you find evidence in unopened email, I may contest that and say, it didn't belong to me. It belonged to the sender. The sender is still the owner of that container, as the sender sealed that container, and it was their container. The owner of the email may have it in there, but it has not been opened yet, so therefore it doesn't belong to that person. So I'm going to question the identity, who owns that, and who actually could produce that file. You can also question on a computer that has multiple user access, something like a dorm room or someone's home, who actually pushed the buttons. Again, I think we talked about it in the introduction, the biology of the technology bridge. What biology to what technology existed to let you, or to be conclusive that this is the individual that pushed the enter key when they sent this email, or they hacked a computer, or they did something. You have to have something more than mere speculation that I'm involved. You have to have something that puts me behind that keyboard, and that can be extremely difficult, and that can be very challenging for investigators, unless the person has a computer that's isolated, no one has access to it. Those are the kinds of things that you've got to prove. Prove beyond a reasonable doubt that I'm the only one that would have access to that stuff. Hearsay rule exists to prevent unreliable out-of-court statements by people from influencing the outcomes of trials. When a computer record contains the assertions of a person, the record can contain hearsay. And this can come down to emails that show guilt, for example. So I send you an email going, "Hey Bob, boy, I'm glad you robbed that store and did all this stuff." And I'm like, "Oh, look at that. You robbed a store." Well, I got to do a little bit more work than that. You can't just throw that in there because that happened to be on my computer and it alleges that I had something to do with it. Also, you got to remember that, again, as we were talking about before, most computer records are EO zeros and ones. So there's the thought of hearsay when it comes to actual computer records. You're not going to see the actual evidence. What you're going to see is you're going to see my interpretation of that evidence as I provided in the court. And the courts will, unless you've done something in the past, or unless you lose your credibility somehow in court, the courts are going to go with what it is that you say is on that hard drive. They're really not going to challenge you too much unless you've been proven to be unreliable in the past. And then business record exemption, most common hearsay exceptions applied to computers. They look at it as business records. These are computer generated, log stamped, unless there's some finding that shows that the computer was doing something weird or is manipulated somehow to only produce records of guilt, and you don't have your inculpatory and exculpatory evidence. Well, then you might run into a problem with this. But for the most part, computer generated records, the timestamps, things like that, usually aren't questioned because they have to have certain things to function on a network, and they have to be within certain time constraints, things like that, to work with servers. So you don't have to worry too much about the authenticity of a computer generated record of stuff. And then the best evidence rule. Best evidence rule states that to prove the content of writing, recording, or photography, the original writing, recording, or photograph is ordinarily required. And this is why we duplicate all of our evidence. So I put the original evidence into the evidence room. I take a copy of it, and I use that copy to do all of my investigating from. That way, when the court comes back later and says, we want to see the original evidence as it was, I don't run any risk of contaminating or destroying the evidence, because the evidence is kept in a pristine manner away on that drive or away in the evidence room. And then I have on my drive a duplicate or a mirror copy that I get to investigate. And then, of course, I'm going to provide my audit trail and my record of my investigation to the court, so there'll be a very clear understanding to the court of what it is that I've done, how I did it, what I searched for, all my keywords I searched, make sure I'm within my scope of the warrant that they've given me, all that kind of stuff. So the computer records, computer printouts, things such as that, they're going to be really important, and they're certainly going to be examined by the defense attorney and by the court to make sure that I did my job correctly. So as you can see, this was a very quick overview of kind of search and seizure and warrants. They're very important, especially when it comes to computer crime, because it's very easy, very, very easy to lose evidence. It's very easy for the courts to throw stuff out if you don't collect information correctly. And police officers tend sometimes to want to short circuit, go around things to get evidence, and every time they do that, they basically lose their evidence in court. With the new containers that are coming out, like cell phones and things such as that have mass storage device or mass storage on them, the rules for cell phones are changing. It seems like almost daily, depending on what court you're in. So it'll be interesting to see, how far and what the new rules for cell phones will be this year and this next couple of years as the Supreme Court changes over. And we have, I'm certainly sure we'll have new rulings and new court cases that challenge the police's right to go onto cell phones and look at data on cell phones. So with that, this ends the overview of Chapter 10. Again, I'd like you to look at the cases on the end. We have a couple of different cases there. Katz is there. I want you like you to go through and read those cases. They're in your book on page. Let me just flip over there to it just real quick. We are looking at page 254. So make sure you read 254. Look over Katz versus United States, Florida versus Riley. Um, there are a couple of good cases to kind of review. Steve Jackson Games is one of those court cases that set made precedents, and it's actually interesting to go out onto Google and actually Google the finding for Steve Jackson Games. In fact, I would go out and do the findings for each one of these and just read what the court said, and you'll find that it makes for interesting reading to see what the government did, how the government did it, and what mistakes the government made in certain situations, especially in Steve Jackson Games. The guy walked out, basically made a lot of money off the government because the government did all kinds of goofy things when they did the search and seizure of his stuff. All right, so we will see you in the next presentation.